Any mention?
May we please, Your Lordship? Your Lordship,
Yes.
I beg to make a mention of item number 10, 16 and 18, Your Lordship. Your Lordship, due to the personal difficulty of senior conducting counsel, I will pray for 3 weeks' time, Your Lordship.
You are respondent.
Yes, for 16 we are, no, for 16 we are the petitioner, Your Lordship.
10 in
For,
10.
for 10 we are the respondent, cantonment respondent. And
Who
for
is the
8,
petitioner?
TP Bhattacharya is the petitioner, so I have been instructed no objection, Your Lordship.
Okay. 10.
and for 18 I am the respondent number 3, Your Lordship.
We have the respondent. Not objected with the Land Council for the petitioner. List after
3 weeks, Your Lordship.
3 weeks. Yes. Then 16.
16 I am the petitioner, Your Lordship.
Who is the other side?
I'm there.
No objection.
No objection.
16. Just say one request made on behalf of the petitioner. List after 3 weeks.
Your Lordship. And item number 18 I am the respondent number 3, Your Lordship.
Item 18 you are appearing for?
Respondent number 3, Your Lordship.
No objection. Okay. Item 18 also on the request made on behalf of the respondent number 3. List after 3 weeks. Yes.
Oblige, Your Lordship.
Please, Your Lordship.
Yes.
I'd like to mention item number 17, Your Lordship. Your Lordship, similar matter is still pending in DB, Your Lordship, so I kindly pray for 4 weeks' time, Your Lordship.
Yes. 4 weeks at the request of the petitioner.
Much obliged.
Yes. Right.
May I please? Your Lordship, I beg to mention item number 11. I pray for 2 weeks' time, Your Lordship.
Who is the other side?
I'm for the state, Your Lordship.
No objection.
No objection, Your Lordship.
This is one prayer made on behalf of the petitioner, not objected to by the learned counsel appearing for the state, running G appearing for the state respondents. So list is matter after
2 weeks, Your Lordship.
yes.
Highly obliged.
Yes.
May I please, Your Lordship, I beg to mention item number 13, 14 and 15.
13, 14, 15, these are all connected matters.
Connected matters, Lordship.
It's 482 matter, my lord.
Yes, you are appearing for?
Respondent number 4. Lordship.
Yes. Yes, sir. On the request made on behalf of the respondent number 4. This is matter after?
2 weeks, Lordship. 2 weeks.
Yes. 13, 14, 15, all this is. Yes.
13, 14, 15.
13, 14. Highly obliged.
May I please, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 19.
Item number? You are not.
19, Your Lordship.
You come near speaker, not near the camera. Just
I beg to mention item number 19, Your Lordship.
19. Yes.
Your Lordship, I'll seek a
Must have
accommodation in this
something
matter.
in there. Yes. What is your prayer?
Your Lordship, due to some personal difficulty, Your Lordship, may this matter be kept after 2 weeks.
This is a matter where my lord.
No, what is the prayer for?
He
I
has
don't
paid
know.
for 2 weeks' time.
Yes.
So this is a matter, my lord. This is a revision, my lord, where my lord we are coming against the order of the London Trial Court, where my petition was dismissed. Subsequently, I filed to restore it, my lord. That restoration petition was also dismissed.
Oh, yes, sir.
Since he is
It's
paying,
not a very major thing, Mr. Paske.
okay, my lord, let it be after 2 weeks, so we can
Anyway,
positively.
it's okay, it's
dispose it
okay.
of.
Just do. Oh, just say. The on request made by Mr. Pierre Paske. On a council appearing for the respondent. This is matter after 2 weeks. Yes.
From supplementary list, item number 1.
Hey, please.
Yes.
My lord, in this case, my lord, I am the employee in the Department of the Directorate of Sericulture and Weaving in Shillong, my lord.
Yes.
After the death of my father, the department concerned, they issued me a letter which to join as an peon officiate, which is dated 5/7/1994,
1994.
my lord.
Yes.
And after that also, my lord, I've submitted the joining report on the same day itself. This is annexure 2, my lord, page 13.
Yes.
After that, my lord, I filed the application dated 7 December 1999 for appointing me on compassionate ground after I've learned that there are some posts regarding with LDA posts.
Your father died in which year?
94, sir, my lord.
And after 5 years,
My lord.
was it not time barred? Anyway, okay,
My
then
lord. After that, my lord, they remain silent. The government, on the recommendation of the Department Selection Committee, which is on the 5/3/2001, they regularized me the post as peon on the 5/3/2001 itself. This is Annexure 6, my lord.
okay, that is without reference to your claim of compassionate appointment.
My lord.
Yes.
After that, my lord, the under Secretary to government of Meghalaya had issued another order for filling up the post of LDA by way of permission. My lord, kindly come to Annexure 8, page 20. If I may be allowed to read, my lord, the page 21 is a typed copy, my lord.
Yes.
From so-and-so, the Under Secretary to Government of Meghalaya, Personnel and Administrative Reforms Department, to the Director, Street Culture and Department Shillong, Meghalaya Shillong. Subject an application for the promotion of LD assistant. Reference your letter so-and-so. So I am directed to refer to above and to say that filling up of the post LDA in the Directorate by permission from Grade 4 staff falls under the Meghalaya Directorate Establishment Ministerial Service Rules, which is in the final stage for appointment. As such, you may act accordingly to the provision made in the aforesaid draft service rule to dispose of the case and the petition by Srimati A. Nyota. I am the petitioner in this instant case. Peon of your office to condition that the quota of 8:1 is maintained in the cadre of LDA assistant.
What is that 8:1:1?
This is the ratio, my lord.
For whom? Direct recruitment 8 and then?
Well,
And one?
One
Next
one is from the typist. 10%, 80% is from the. I'll come to that, my lord.
Okay, all right.
My lord, after that, my lord, the director remained silent about my application for appointment on a LDA basis, my lord. However, in 2004, they issued another letter which allowed me to officiate as typist, which with one Srimati G. Nonkandri, officiate as LDA, as Law Additional Assistant. Again, my lord, in 2006, 28 August 2006, I've also made another reminder requesting over the same issue for affecting hair promotion as paid by me earlier. And then also, they still remain silent, my lord. However, the director, in the order dated 3rd November 2011, had also informed me that due to heavy workload, this is, my lord, can you come to Annexure 12, my lord. Page 27, ma'am.
Yes.
After I've submitted reminder 2006, they issued me this letter, whereas they remain silent all those years. Here, my lord, due to heavy workload of diaries in the receipt and issue section of this directorate, it is hereby informed to Srimati A. Nyota, typist, to assist this section in addition to line over duties specifically over with the subject matter of the departmental letter to be received and issued from within office of the district of the state in order to enable to locate and dispose smoothly and immediately. After that, my lord, another letter again in 2019 was also issued by district government, by the department concerned. There is 6/8/2019. This is Annexure 13, my lord. Page 28, my lord. Number so-and-so, H. Kharmalki, LDA, Directorate of so-and-so, is hereby granted committed leave on so-and-so from the period so-and-so being
Yes,
already.
you have been given
yes,
the
my
duty
lord.
to look
yes,
after
I
these
was
duties.
assessed
Then?
on this particular. And after that, my lord, the directorate, my lord, white order,
Yes, you have been given promotion in 2023.
my
Page
lord,
29.
my lord, my lord.
Then what happened?
Annexure 20. Subsequently, my lord, unsurprisingly, my lord, after joining this LDA post in the year 2024, dated 16 August, they issued me another letter where they demote my service.
Where
Kindly
is
come
that?
to-
Where is that order?
Kindly come to page, annexure 15, page. Page 31, my lord.
Yes.
If I may be allowed to read, my lord. This is a typed copy of the annexure 15. From so-and-so under Secretary to Government of Meghalaya Department of Textiles to the Director Agriculture and Weaving, subject permission to the post of LD in respect of Srimati Agrisha Nyota. Madam, in continuation to the department letter number so-and-so dated 6/5/2000, I am directed to request you to kindly take necessary action on the following. Based on the decision of the Department Promotion Committee held on the 23rd December 22 on agenda number 2, Srimati Nyota, grade 4 staff, is to be promoted to the post of LD assistant. You are hereby advised to treat her promotion as cancelled. In view of the personnel department of observation indicated in this department letter mentioned above, but
What is that?
Shall
What
I-
is that letter?
my lord,
Where is that letter?
page 31, my lord.
No. The reference. It has made a reference of the letter, isn't it? In view of the personal department's
My lord, my
observation
lord.
indicated in the department's letter mentioned.
My
So
lord.
where is that letter?
Here, my lord,
That means letter dated 6/5/2024. Where is that letter? So you do not know for what reason you have been demoted.
no, my lord, for unknown
That
reason.
is why this letter was necessary. So you do not know what is this. This is a reference of this. Letter number is given, date is given,
My
and
lord.
you do not know what the letter is. Yes. How can you give promotion and withdraw it?
Lordship, in the same letter, it says at point number 2, you're also requested to take up the matter expeditiously for regularization of her service at the earliest. I'll have to seek instructions on this also, Lordship.
Definitely, you have to take instruction. It
Lordship,
seems very unusual that you promote somebody and then you demote. And promotion has
yes.
been made.
But it quotes DPC also over here, Lordship. Yes.
See, promotion was made
Yes.
after her name was recommended. That is the main thing. It is not that some officer just choose her and give her this.
Lordship.
Anyway, we'll issue notice, you take instruction.
Lordship.
Yes. Hard. Issue notice returnable in 3 weeks. MSNG, Silla Learner Senior GA APS for all the respondents.
Oh.
Hence, no further notice is called for. Check. The learner senior GA shall obtain necessary instruction. List the matter after 3 weeks.
3 weeks. Much obliged, Lordship.
Highly obliged, my lord.
Item number 2.
Yes.
May please, Your Lordship.
Sorry.
Your Lordships, here, the petitioner is the wife, Your Lordship, of late Shri Marius Pathau, Your Lordship, who during his lifetime had served.
Say it again. The court could not follow. Yes.
I'm so sorry, Your Lordship. Your Lordship, the petitioner herein, Your Lordship, she is the wife of the late Shri Marius Pathau, Your Lordship. Your Lordship, who during his lifetime had served as a storekeeper in Meghalaya State Pollution Board, Lumpangat, Shillong.
In regular capacity.
Your
Was
Lordship,
it in regular capacity?
in regular capacity, Your Lordship. Your Lordship, the petitioner and the deceased husband, Your Lordship, they had been married since the year 2021, 2001, Your Lordship. And the same marriage, Your Lordship, it was solemnized before the Divine Saviour Parish, Shillong. After that, Your Lordship, one issue was born out of the said marriage, Your Lordship. Now, suddenly, Your Lordship, what had happened was in the year 2016, the Sri Marias Pathau, Your Lordship, he expired, Lordship, suddenly due to illness. Due to illness, Your Lordship, he passed away.
He passed away,
Yes,
yes.
Your Lordship. In Woodland Hospital, Shillong, Your Lordship. Now, Your Lordship, the cost of the expenditures of the funeral services, Your Lordship, were borne by both the petitioner and his siblings at their
What is
residence.
to do? If she's wife, that is okay. Whether she
Lordship.
anyway, it means there is a dispute.
No, Your
Are
Lordship,
you-
there is no dispute, Your
Your
Lordship.
submission has that kind of implication.
No,
that
Your
there is a
Lordship. I will get to that, Your Lordship. So, Your Lordship, after his demise, Your Lordship, the wife now, she wants to claim the debts and services, Your Lordship, which are entitled to his service during his
dispute. That
lifetime.
will be there. That will be getting as per the service rule. Why not?
Your
She
Lordship.
should get it.
Your Lordship.
So she is a recorded wife in his in the
Lordship.
deceased official record.
Yes, Your Lordship.
Okay, then-
Now, Your Lordship, she has also obtained the no objection certificates from both the siblings, Your Lordship, and the
Not
only
required,
surviving
It's not
heir.
required.
Your
Where
Lordship,
if she is there, why?
Your Lordship, herein, Your Lordship, lies the problem, Your Lordship. She had approached the concerned office, Your Lordship, to ask them for the details of the debts and
She has not
ship-
been given.
No, Your
So
Lordship.
that is the purpose you have here.
Yes, Your
Yes. Why
Lordship.
you are not releasing the service
My lord.
benefit of the deceased to his wife?
As my friend has submitted, the deceased was an employee of the Meghalaya Pollution Control Board.
Yes.
I don't represent, my lord. I represent respondent number 1,
Okay.
my
So
lord.
pollution
notice has
control
to
board
be
is what?
issued.
It's not under government.
No, my lord, because, my lord, all the documents and even the averments are against the Pollution Control Board, my lord.
No. That is a pollution
So, and
government
there
is
is
not
no
under the state.
correspondence in which a state would have been, my lord. There is no correspondence also in which a state has actually
No. Just
not allowed.
are
or
you
some-
are you saying that pollution control board does not fall under? It's not a
No,
state
my lord.
department.
They have a council appearing, my lord. They
Forget about the lawyer.
separately, my lord.
I'm asking whether it's a government department or it's not a government department.
No, my lord. It will not be entirely a government, my lord.
It's some
It's
kind
a
of
board, my lord.
undertaking.
Statutory body, my lord. So it will not be.
Autonomous body.
My lord.
Are you sure? And then we'll issue notice.
So notice will be issued, my lord. 2, 3, and 4. I represent 1.
If somebody dies in 2016, why is till this 9 years? You'll appear for?
1, my lord.
Okay. Hard, Ms. So-and-so, issue notice, she returned over in 3 weeks. MSR Colony, Lanet GA, appears for respondent number 1.
1, my lord.
Yes, the petitioner shall take steps for service of notice upon the respondent number 2, 3, and 4 within 2 days. List after 3 weeks.
Much obliged, Your Lordship.
Item number 3.
Yes.
May please Lordship. Lordship, this matter pertains to a family pension, Your Lordship. Here, Your
False.
Lordship.
Government is not doing anything. When? Family pension of
Family
deceased
pension
or
of a deceased, Your Lordship.
family?
Your Lordship,
we-
here I am the wife, Your Lordship, of late Harold
Okay.
Dakar, Your Lordship.
Your husband was a pensioner.
Yes, Your Lordship. Your Lordship, he was initially appointed in the year 1993, Your Lordship. Thereafter, he retired in the year 2023, Your Lordship. On retirement, he approached the office of the respondent, Your Lordship. However, no action was taken from their part, Your
He
Lordship.
retired in 2023.
Yes,
And then
Your
he
Lordship.
did not get pension.
No, Your Lordship.
And then now he passed away.
Yes, Your Lordship. Unfortunately, he passed away, and now the wife, Your
So
Lordship.
It means during his lifetime, he did not receive pension.
No, Your Lordship. Soon after, he retires on 1st 3 2023, and after 3 months he died, Your Lordship. On
After 3 months
23rd
he
6
So
2024.
before that,
Yes, Your
pension
Lordship.
pension
Did
was
not
there.
receive any pension.
Yes.
I'll have to take instructions, Your Lordship, for
Yes,
respondent 1, 2, and
this
3.
pension matters and all. You
Yes,
should
Your
not wait for court's direction.
Yes, Your Lordship.
If something can be done from your end, you should do it. Yes. Same order, hard. You should notice. You will appear for all the respondents.
1, 2, and 3, Your Lordship.
Okay. What about 4? You will take steps.
Yes, Your Lordship.
We just say same order, then say MS Ilingual under GAPS for the respondent number 1, 2, and 3. Stop the petitioner shall take steps for service of notice upon the respondent number 4 within 2 days. Then list after 3 weeks. Yes.
Much obliged, Lordship.
Item number 4.
Yes. Yes, Mr. Momin, what is this?
My lord, they have filed a revision petition, my lord, under Rule 6.
Who have filed?
The petitioner, my lord,
Oh, Mr. Paske.
Paske. So we're challenging the maintainability, my lord.
You have challenged the material.
Yes, my lord.
On what ground?
On the ground that appellate forum is available, my lord, they have not exhausted the remedy, my
Is
lord.
it? This is a revision against what?
This is the revision against the final order, my lord,
Of
the title suit, my lord. Annexure
in a
10.
civil matter.
Yes, my lord.
So what for this miscase is there? Miscase is for what?
No, it was already condoned, my lord. We have not objected to that condonation of delay.
What is this miscase?
They have filed for condonation of delay.
Oh, this is 25, miscase 25. So that has already been
That has been condoned, my lord.
condoned.
Yes.
No. How do you say? Is there any order? No. There is no order. This only notice has been issued, then you appeared. There is no order. Where is the order?
No, we have not pressed, my lord, that condonation of delay, my lord.
You have not pressed means you have not objected, you
I have
can
not
say.
objected, my lord.
Yes, that is okay, but then where is the order by which condemnation was did? We are yet to admit this thing. Revision. We'll just condone the
No,
delay.
it was posted for admission hearing, my
We'll
lord.
condone the delay and list it for admission.
Yes, but
There
I
is
was
no
of the
order.
impression, my lord, that lordship has already condoned it because last occasion I've
You should
already.
check the order sheet. Just give it.
Lordship.
Just see. I don't think there is anything. If you have any information, just check. Was it condoned, Mr. Paske? Delay. Give him the order sheet. Let him check. Now you are totally. You are not at all audible. Not possible. This is difficult this way. Anyway, we will condone the delay and this thing. I don't think there is any order.
No, it's there, my lord. 24/3/2020.
Yes, what does it say?
It says like Mr. A.G. Mohammed Learned Counsel appearing for the respondent submits that on earlier occasion time was granted to file objection. The respondent, after going through the matter, decided not to file the same. Here, however, submits that the respondent would like to challenge the maintainability of the revision application. As prayed for, the parties list the matter for admission hearing.
No, that is a wrong thing actually. You should have condoned the delay first. The delay has not been condoned. So we have to do it first.
Yes,
And
ma'am.
then we will list it.
Yes, ma'am.
Yes. Just say, this is miscase 25, huh? Third, Mr. Paske, Learned Counsel appearing for the applicant, and also Mr. Momin, Learned Counsel appearing for the respondent. By this application, the petitioner has sought for condonation of delay of 139 days in filing the accompanying revision petition against the impugned order dated 25/4/2024 passed by the learned assistant judge, District Council Court, Garo Hills Autonomous District Council, Tura in title suit number 12. Stop. Reasons for delay have been satisfactorily explained in the application. Stop. Mr. Momin, Learned Counsel for the respondent has no objection to the prayer of condemnation of delay. Stop. Paragraph. Accordingly, this application states note delay of 113 days in preparing the connected revision application is the registry to diarize the revision application district for admission. Yes.
Deeply obliged, Your Lordship.
Item number 2.
Yeah, application dispose of last time.
Counter in file.
May it please your lordship.
Yes.
Lordship, the main issue before the division bench is coming on 25th June.
Oh, actually, it is that matter connected with the affairs of these things. So what is to be done now, Mr. Sulai?
Lordship, this has to be just simply adjourn, your lordship. Whatever be the outcome of the writ appeal, then we will inform your lordship accordingly.
Yes, the Learned Council is paying for the party submit that a connected matter pending before the division bench of this court is yet to be disposed of. Stop paragraph in view of the submission. What is this matter after?
It will be after 4 weeks, your lordship.
4 weeks.
After 4 weeks. Offline.
Item number 3.
Let it happen.
Yes. Yeah, in this matter, this is a criminal writ petition. This criminal writ petition is what? It is praying for
This
what?
is against the order of the Lok Ayukta, your lordship.
Ordering some investigation.
Lordship.
Okay.
Stay will not file, your lordship.
Okay.
It's an interim order, Lordship. Kindly allowed to continue.
Okay. Just MS Jatti Sangma, Learned Council appealing for the response number 2. Praise for grant of further 2 weeks time for filing the affidavit in opposition. Stop. Prayer allowed. List after
Lordship, it's an
2 weeks.
interim.
2 weeks.
The interim order passed earlier shall continue. Oh, it's already there until further orders. It's not needed.
Apply,
So
Lord.
it is last time. It's not needed. It is there. Check the order.
Lordship.
Yes.
Item number 4.
Yes.
My lord, this is an application under Order Rule 6, my lord. This is a revision petition, my lord. So,
You are the petitioner here.
yeah, I'm the
You
petitioner.
have changed the side.
I'm the side, my lord. So I'm aggrieved actually by the order, impugn order passed by the Assistant Judge District Council Court, my lord. So, my lord, I do not know whether they'll be having any objection, will be filing any objection. It's up.
Your Lordship,
Yes,
I'll be
revision
filing an
application,
objection.
filing objection is not
Then,
very necessary. Now, this has come up for what today?
It's for orders, my lord. So it may be posted for hearing, my lord.
Okay, Mr. Pascal, you are supposed to take instruction in this matter. So, probably you have received instruction.
Yes, Your
The
Lordship.
matter is ready for hearing, so you can release for hearing, or is it?
Yes, Your Lordship. But
Release
if my
it for hearing.
Lordship
Release it
permit
for
me,
hearing.
can I?
Huh?
If my Lordship permits me, can I file a small objection?
This is a revision application. What for you need to file an objection? So unlike a writ petition, you do not have to file anything. If required, then we will see during the course of the hearing. If any factual
Then that may be listed for hearing, Your
if
Lordship.
any factual rebuttal is needed, then only you file it. Otherwise not. Okay. Just say Learned Council let me have the parties submit. Parties submit that the matter is ready for hearing. Stop. Let's wait for list after when?
3 weeks, my lord.
3 weeks for hearing. Yes.
Hello, my lord.
Item number
Deeply obliged, Your Lordship.
Please, your lordship.
Yes.
Lordship, I'm still waiting for the instruction, your lordship.
It's okay. Let's wait for by Mr. Sangma.
A.M. Pala, your lordship.
Why this AM Sangma here is written?
He's my colleague, your lordship.
Okay. He is not GA.
He's the GA, Your Lordship.
He is also a GA.
Yes, Your Lordship.
You are also a GA.
Yes, Your
So
Lordship.
you are appearing this matter.
Yes, Your
Okay.
Lordship.
Yes. As per for by Mr. A.M. Palla, learned GA appearing for the state respondents. Further, how long? 2 weeks time
2 weeks, Your Lordship.
is granted to take obtain necessary instruction. Yes.
Obliged, Your Lordship.
Obliged.
Item number 6.
Yes.
May I please, Your Lordship? Lordship, we have taken step for the private respondent, Your Lordship. Still waited for the delivery report, Your Lordship.
6 to 7. This one number
6 and
6.
7,
6 and 7.
Your Lordship.
This is waiting for service report.
Your Lordship.
What shall we do? Shall we wait for some more time, or you will verify the status and file an affidavit?
I already filed the application to verify the status, Your Lordship. So we
Okay,
have
so
waited.
once you receive the receipt, then you file the affidavit before
Your
this court.
Lordship.
Okay. The office note indicates that the report of service on the respondent number 6 and 7 is yet to be received. The petitioner shall verify the status of service and status of service in respect of the respondent number 6 and 7 and file an affidavit to this effect. List after 2 weeks.
Your Lordship. Obliged, Your Lordship.
Item number 7.
Now this is another strategy perhaps. This court will not be able to dispose of the matter on merits in absence of the petitioner.
Very
That is what the law is.
Very unfortunate, yes. And we will not like also, Your Lordship.
Yes.
Very.
None appears for the petitioner. Just say so and so are present on behalf of the
Next week,
respondents.
Next week, Lordship.
Next week we will have this thing or not, because as part she is not there today. Last thing is the things are tight actually, because this court has to sit in division bench for 3 days.
I am
There
aware.
are too many single bench matters also in defense, and then
Lordship, we'll
take
just
up-
make an attempt.
Okay.
Ah,
Okay.
So that,
Ms. So-and-so, sir. List after 1 week.
Lordship, obliged.
Item number 8.
No appearance for the parties. List after 2 weeks. Yes.
Item number 9.
Yes. None appears for the petitioner. Mr. Harwanlang, learned senior G, is present on behalf of the respondents. List after 2 weeks.
Item number 12.
My Lord, this matter relates to promotion. Lordship has done the extensive hearing. The last occasion, my Lord, when the point reached whether promotion given to the private respondent before completion of 17 years of service under the rules is correct or not. And secondly, they have published the gradation list seeking objection for within 30 days. But before expiry of 30 days, they have given the promotion. So this would relates to record. Therefore, Lordship
Yes,
allow the
you have your
LHGA to
instruction.
obtain instruction for that.
We have the instruction, Your Lordship. Lordship, just to recapitulate, three things are involved in this case. First thing, Your Lordship, he argued very vehemently.
Court basically has forgotten almost the thing. Anyway, just
Lordship will recollect.
court remembers that at least you were asked to take instruction on 2 points.
I'll come to it, Lordship. Just to recapitulate so that it'll be easy, Lordship. I will not take much time, maybe just another 5 minutes. First thing was, Lordship, he relied on a judgment that says continuous break. Lordship will recollect. Like, even if there was a transfer, but the judgment went against him. There's a break in service. He was arguing on seniority, and if there's a break in service, he relied on 2000, I think if I'm not mistaken, and Lordship, the judgment is with him. So he relied on judgment, and then finally the issue came that whether that part of the judgment goes against him because it's an admitted case, there was a break in service. So the issue of seniority will not count. We are not into that. Just to recapitulate, Lordship. The second issue was graduation list was published under the rule. It's an admitted fact that requirement of issuing notice is not in the rule. But then state as abundant caution had given them a notice that if anybody has got any objection, please kindly file a objection.
Yes.
What should we recollect? That is the official stand in the affidavit of the state.
Yes.
Lordship has recollected.
Partially, just
partially, yes. So
there is no written note of submissions. Yes.
Lordship, there are two things that let's to clarify. That gradation list. I'll just come to Lordship just to make it clear. Lordship will just come to page 77. Just to make 2nd August 77. So it will be easy for the Lordship to recollect the facts. Type copy, Lordship. Continuous service was which judgment?
Yes.
No, but yes. Which specific judgment? Lordship, this is 2nd August 2021. In pursuance to the notification dated so and so as per clause 15 of the rules 2017, the gradation list for different ministerial staff of PHE department as on 30 July 2017 is hereby approved as Penix shown enclosed. You are hereby directed to circulate to all incumbents in your circle and let this director know if there is any objection on the draft graduation list within 30 days of the issue of letter. If no objection is received within the period, the draft graduation list shall be treated as final for all purpose. So this document is very important also. Though there is no requirement for notice under the rules, Rule 15, there is no requirement for calling for objection. That is their case also. So, but notice was given.
And no objection was filed.
Lordship, it's an admitted case. In their writ petition, they have not said they filed an objection. In the entire writ petition, Your Lordship. In the pleadings, they have not stated anywhere. They have filed either oral or written. No way they have stated. Now, what they state, Your Lordship, is they will make a first attempt to say that it was an oral objection in the rejoinder. In the rejoinder affidavit, Lordship will come to para 7 of the rejoinder. So far pleading is concerned, the writ petition is silent on the writ petition, but rejoinder. Now whether that is permissible.
What is challenge here against the gradation or?
Gradation, Your Lordship. Gradation law. Gradation. So there are three important. First issue, Lordship has gone against him because of the judgment that says that continuous service, that doesn't hold.
I don't know where we have gone. This is, see, the observation made by the court during the course of hearing. Sometimes it is only a passing observation, nothing else. It's a passing remarks. It doesn't constitute to
then it's okay, Lordship. What the issue is gradation list. Now there is no requirement for notice, and in the entire writ petition pleading, there is nowhere they have whispered whether there was written objection or oral. First time they mention is only when the state files an objection, and that too in the rejoinder. Lordship is a settled principle of law that you can give clarification in rejoinder. You can't build up a new case which is not
Definitely, there is no question.
Absolutely. So, Lordship, you find in para 7, they said the claim of the respondent that the answering deponent has not raised any objection against the gradation list is incorrect. It is to be mentioned here that the answering deponent has already raised a verbal objection for the first time he had sent a letter bearing letter source 1, 12/4/2021, which referred to gradation list prepared by so and so. So
Verbal objection in official procedure.
procedure.
So,
Lordship,
what value it carries in
Lordship,
law?
absolutely. And there, Your Lordship, there's no date mentioned, no timing mentioned, nothing. And it's neither here on the first of all whether the court will take cognizance of this particular fact of verbal in a rejoinder. My respectful submission will be no. And then even if court take cognizance, Your Lordship, is just a omnibus statement without date, without timing, when and where. So in other words, Lordship, the gradation list of 30, the gradation list which I read out, Lordship, draft gradation list, 2nd August 2021, has a finality. There are two legal consequences, Lordship. If they don't file an objection, technically they have waived their right.
The seniority list is date when? When is it dated?
Seniority list, Lordship, the draft gradation list is at 2nd August 2021.
After that, was there any publication of final gradation list?
Yes, Lordship, 30 July 2000.
Which is under challenge here? That is 30th July of
2020.
2020.
21.
And then this writ petition is filed on?
Writ petition is of 20.
Okay, so that is not very old.
No, they are not. Right?
So immediately after publication of the thing they have come.
Lordship. So the two things, Lordship, that follows. Once you waive the right for objection, if it was circulated, then, Your Lordship, the gradation attains finality. In other words, the subject matter of the gradation list becomes fait accompli. And they cannot raise the issue because they have waived the right.
Yes.
So, Lordship, so far gradation list is concerned, and it's a settled position of law. I'm sure my learned friend also will agree that this position of law, once you waive the right, you cannot raise the issue. Then, Your Lordship, very important thing that came up was, Lordship, while further argument, he says respondent number 8. Now, the issue is respondent number 8. Lordship will kindly
Who is representing respondent number 8?
Respondent number 8 is in the final list of 30 July 2000.
No, who is representing? Is there anybody who is representing respondent number 8?
No, not required, Lordship. I'll satisfy.
The notice was served.
Yes, I'll satisfy you, Lordship, why it's not required. So, 30 July 2021 is the gradation list, final gradation list, in which respondent number 8 is in serial number 1. Courts, then an argument was forwarded that he has not completed 15 years, apparently. So, if he has not completed, whether his promotion itself, there are two things, Lordship. Appearing in the list is one thing, and his promotion is totally different. Could the state have considered? We have to just look at the rules, whether he had completed 15 years or not. Lordship, on that basis, the matter was held.
What is the rule?
And Lordship will just come to the relevant rule.
Rule is that?
6.
Where do we get it?
We get it at page 61. 2017 rule. Page 61, 6, clause C, subclause 2.
Page 61.
This is the only limited issue right now, Lordship.
Yes, this is rule. You are referring to rule
6.
Yes.
Our concern here is C, Lordship, lower division assistant appointment shall be made. And then specific is subclause 2.
Yes.
By selection from the select list. Lordship, every vote is very, very important, Lordship. So there are two things involved here. By selection from the select list.
Prepared under Rule 8.
Prepared under Rule 8. From amongst the peons of respective district circle, division office who have passed SSLC or examination declared equivalent thereto and have rendered at least 15 years of continuous service in the establishment on the first day of the year in which the selection was made. Lordship, allow me to read the last line, very important, because we are very interesting drafting of this rule is there.
Here we are concerned with the post of law divisions.
Yes, and peon. Specifically peon. Lordship, this is very wide.
No, the promotion is sought to which post? Is this like
LDA? LDA. Lordship, this rule is very peculiar because first time, I mean, I have to honestly admit it, Lordship. First time I saw such a interesting and a peculiar drafting of the rules. And why it is peculiar, Lordship? Lordship, can you just read again with me? The last part. 15 years of continuous service in the establishment. Lordship, on the first day of the year.
Yes.
In which the selection was made. So the counting point will be the first day of the year, Lordship.
Exactly. You are correct.
Lordship, irrespective of the date of appointment. That's why, Lordship, I made a candidate submission. I've never come across such interesting drafting of the rule. Maybe for administrative reason. So the counting of the date will be the first day of the year.
Exactly. It takes care of it.
Absolutely.
It's all right.
Now, Lordship, we come to the gradation list straight away, Lordship. Now we come to page 80.
Page 80.
80. This is the gradation list.
Wait, Mr. Khan, just court will take note of things.
80.
Yeah, just a minute. Page
80. It's a type copy, Lordship, of the. This is the final gradation list of 30 July 2021.
Yes, please.
Lordship, from the starting it is 4, 5, 6, 7, 8. We are not concerned with that. We are concerned with Group D post peon.
Yes.
Number 1. Number 1 is R8, Lordship.
Okay.
Who is number 1 in the gradation list of 30 July 2021?
Yes.
Now, Lordship, in column number, not the first, second, third, fourth.
Yes.
Fourth is very important, Lordship. His date of joining is 12/9/2006.
Yes.
Lordship has got it.
12/9 or 12/10?
First, I reading the first part. 12/9 is under the head. It comes under the head of 12/10. Date of joining is 12/10, Lordship. Okay. To be precise, 12/10.
Yes.
And Lordship will see it serial number in the same page. Serial number 5 is the petitioner.
Yes.
Lordship will see the column. His date of joining as peon in the last part, Lordship.
11/5/2016.
11/5/2016.
Yes.
So R8 joined on 12/10/2016. Petitioner joined on 11/5/2016. So petitioner doesn't come within the meaning of 15 years. Number 1.
So he doesn't come to the
No, Lordship. So we are not arguing for petitioner. That has already been taken care. He has already made a self-goal, Lordship, by that judgment. The only issue is this 12/10/2006,
yes,
whether he has completed 15 years. At this point, we stopped the other day. Lordship, if you take 12/10/2006, if you take this particular date,
yes, we have calculated it.
Lordship, then 12/10/2021, 12/10/2021 will be 15 years, Lordship.
But then since we have to take the first day of the year.
No, Lordship, absolutely. 12/10/2021 will be 15 years. But if you read again the rules, Lordship, 6(2)(c). Now let us go back to the rules again.
We have to see, that is clear. The first day of the year.
Lordship.
It should be as on 1st January 2006.
Lordship, that means 1st January 2006 to 1st January 2000.
Yes.
1st January, we have to interpret the rule. 1st January 2006 will be the day starting point, and 1st January 2021 will be the end point. That clearly is 15 years.
Yes.
So there is no illegality.
And all right.
Subject to further clarification, that is the case of the state.
It's all
It's
right.
not- no information.
Yes, Mr. Sangresham. Probably that clarifies the thing. Though this court has probably taken note of your submission earlier, would you intend to give us it in writing some notes or?
I'll just give a short rejoinder. The state respondent is not
Rejoinder.
state respondent is not answering the queries made by my lord. Whether my eligibility is one thing, and eligibility of the private respondent number 7 or so on. Now, the early occasion we argued that I joined in 1999. The department has ignored my previous service, therefore, that ignoring my past service is illegal. That is my stand. If my seniority is counted from 2016, I admit that I did not fulfill 17 years. But that is not my case. My case is I have more than 17 years.
You have argued that. You said your past service from 1999 was ignored.
Yes.
Now that we have taken note of.
Yes. That is because of I cited the judgment also. Now the question now here is whether the private respondent who was promoted has finished 17 years.
Say it again, please again. Repeat it again.
Whether the appointed promotees has completed 17 years of service at the time of his promotion.
Not 17, 15 years.
17, well, if I recall from the rule, it requires 17 years.
No, what is 15 years? That is what has been read out. 6C.
No.
6C is Roman 2.
15 years. 15, I stand corrected. So
memory still works.
15 years. Yes. My contention is that private respondent did not complete 15 years. And that is very clear in this. Lordship, can you see?
You see, you have taken this, we have taken note of this.
Yes.
We asked for a reply. Mr. Khan has given his reply. So we have taken note of that also.
Yeah. My lord can take note of that. That's true. But
now, like if you say that Mr. Khan's explanation lacks some, you see, there is a lacking, then you just point it out.
Therefore, I'm pointing out that one. I'm pointing out. Lordship, here the page number 80.
Yes.
Serial number 1 of the promotee.
Yes.
His appointment was 12 October 2016. 2006. And he was promoted on 2021. We can see by his submission, 1st January 2021. He must complete 15 years. Then only he is eligible. Lordship, can you see page number 83? His promotion. So less than 15 years.
All right.
That is one thing. And second thing, my lord, the accreditation list, which they have published, page number 77.
Yes.
I'll clarify 2 points, my lord, from page number 77. Now, the rule is framed under the notification was, accreditation list was published.
Yes, just come to page 61, that rule. Let us just reappreciate the rule.
Yes.
Perhaps what you say, you are correct. Just see.
61. 61, my 62.
Yes.
My lord. By selection from the select list prepared under Rule 8 from amongst the peons of the respective district, circle, division office who have passed SSLC or any examination declared equivalent thereto is one part, that is academic one.
Yes.
And have rendered at least 15 years continuous service in the establishment on the first day of the year in which selection is made. Now, selection, but
so it means on the first day of the year, 1st January, he should complete.
He should complete. He did not complete. He is not eligible in that case.
Yes.
If we take that this gentleman, Lordship got it, my lord. And secondly, my lord, I'll come to that page number 77. I'll clarify quickly.
But then the thing is that, okay, just let us assume that we find it correct. You uphold what you say with regard to the qualification of the private respondent.
Yes.
But then if you yourself do not qualify,
yes,
will you have the locus standi to challenge?
My lord. Therefore, my lord, if my counting of 15 years started from 2016, I'm not qualified. I wouldn't file the petition also. But since my past, I joined in service from 1999. According to me, I was qualified.
So your contention will be dependent on the fact that if court finds that your past service should have been considered.
Yes, yes.
Now, if you find that that is not considered, that say supposing if you hold that no, your date of joining is 2016.
Yes.
In such a case, your challenge.
Yes, it will go.
Of non-completion of 15 years also will may not last.
It doesn't
may not go away because of law.
Yes, yes. Once I understand, I don't have a locus. There's no question of interference with the action passed by the department. But once Lordship hold that yes, past service cannot be ignored, then in that case, my Lord, the Lordship can enter into the eligibility of the private respondent number 7, the private promotees. And my Lord, we can see page number, they are saying the objection regarding objection. Page number 77, the gradation is.
Page number 77.
Because since the learned AG has revisited this
that is the notice calling for objection.
Objection. Now I would demonstrate.
Just a minute.
I would demonstrate with Lordship permission.
Yes.
My Lord, this rule was pursuant as per clause 15 of the Service Rule 2017. This gradation was published. My Lord, approval of gradation list of ministerial staffs.
You say that you are referring there?
Yes.
What you are saying that it was
subject, let us go to subject. Approval of gradation list.
Yes.
It is not, my Lord, the draft list also. Approval of gradation list of ministry staff of the department. Now, in pursuant to such and such, as per clause 15 of the Meghalaya Ministries District Established Service Rule 17, gradation list for different ministry staff of the PG such is hereby approved. My Lord, kindly see.
Yes. So, right. Please come.
Now, approve. Now, you are hereby directed to circulate all the incumbents in your circle and let this department know if there is any objection on the draft gradation list. They use the word draft gradation list within 30 days of the issue of the letter. If no objection is received from within the period.
Whatever we say, it is approved or draft, but then that approval also was subject to the objection.
My Lord, it is not.
Approval has two stages. What is preliminary approval, another is the final approval.
My Lord, if I may take to that rules now, it's very clear. Page number 60. Page number, my Lord, 63. Rule 15 is very clear.
Page 63.
Yes. Once they approve and publish it, there is no question of draft seeking for objection also.
Yes.
My Lord, 15, gradation list,
yes.
How they prepare. A gradation list of the members of the service in the district shall be prepared by the head of department, circle division concerned, and the same shall be approved by the head of department and published from time to time. Now they say they have approved under Rule 15. So that is final. Therefore, the second paragraph.
That is okay, but then once they call for objection, that means that is not final.
Well, I'll come to that.
That is something like semi-final, not very.
My Lord, if Lordship, assuming that that is exactly correct, Lordship may kindly come to page number 77 again. We appreciate the second paragraph, second part. My first part is that, my Lord, it is the approved one, the final one.
Yes.
Seeking for objection is, my Lord, they just mentioned. Second part is seeking for objection within 30 days. Now, this was published on 2nd August.
We have taken note of that. You have taken it earlier. That before completion of the 30 days, they have accorded promotion.
Therefore, my Lord, it is an empty formality once they approve it.
But then, see, it was for a person who filed objection, basically on who would have filed objection. Even there is nothing to show that even after the completion, though they might have given promotion, but then you have filed your objection within that period of 30 days.
Or
so once you do not do it, whether they have done it on the 25th day or 26th day, it doesn't matter.
Or a
if you can show us on record that your objection is there and that is filed within the 30 days stipulated period, then we may consider. Otherwise,
my Lord, according to me, my Lord, oral protest is sufficient. unless the statute provides. The rule itself provides that the notice should be given, notified to the gradation will be notified to
Then
the
in
employees.
such a case, even that notice is not provided in the rule.
Therefore, my lord, therefore, for the fairness of the, for the convenience of the department, they have done it. It is not a statutory mandate.
That is okay, but
My
then,
lord.
then
And
that's
therefore,
all right.
department acting
Now,
beyond the.
Now, if you are saying it's until and it is provided in the rule that you see like protest should be in writing, then barbaric protest should also be entertained. Now, if that be the thing, then even the 30 periods also, if you give the same interpretation, then 30 periods also, 30 days also, it comes in that way. You see, like it is
Irrelevant.
not provided in the thing. So
irrelevant.
if it is given, it is a kind of grace whether they comply or don't comply. Doesn't matter.
But it is irrelevant.
Adopting the same line of argument.
My lord, if it is a statutory mandate that the employee should give in writing, and I fail to do that within 30 days.
Mr. Sangdesho, will you do one thing, just for the convenience of the court? Can you just give us just short notes of your?
I'll
do not make it lengthy.
Yes, yes.
Just
One page.
1.5 page.
Okay, 1.5 page.
Okay.
We can do that.
Just like that, what you said.
We can do that.
That you see, like promotion accorded before stipulated 30 days period. This is one point. Second point is that did not complete 15 years
also.
given so just like that.
I can do that.
If you can do it, then that will basically.
Yes, I can do that. But because the judgment, I don't need to refer again. It was refer already. So promotion given to the respondent is not tenable in law, and not may interfere with, and the relief sought for in the writ petition may be considered and granted. That is my humble submission.
When can you give us this thing? Just a written note. Next week.
I can give. Yes, within a week's time. If the
We'll just have it after a week so that
yes.
comes up before the court forgets.
Yes, we would.
Okay. The arbitration appeal for the parties have concluded.
Lordship, just one concluding remark.
Yes.
Lordship, can you just come to page 17? of the-
Rejoinder the reply to rejoinder.
No, just 117, like what you have stated, Your Lordship, everything cannot be considered. Right now, after the rejoinder, nothing can be considered because of the own pleading. Page 17, para 7. Just for a moment, Lordship.
Page 17.
Para 7.
Page 17 or
17. The page
of the writ petition.
Writ petition, Lordship, yes.
This is a prayer.
Not prayer, 7. Ground, on the ground,
yes.
7. Ground
Yes.
7.
Yes.
Right.
Lordship,
Yes.
this is their pleading.
Yes.
Not to allow the argument to become academic, Your Lordship. If the pleading is very specific, that the above rules of 2017 have prospective effect.
Yes.
And therefore the rights acquired by the employees cannot be taken away by the above rules or by executive action.
So far as his past service is concerned, that is what he says.
Absolute, Lordship, the moment they admit on pleading, prospective, so their appointment is of 2016 and it is governed under the rules. So anything about past, anything about this, Lordship, can be taken by their own admission.
So if it is prospective,
everything
then
will be governed by the.
we cannot go back.
We cannot go back. So entire argument on
My
past
transfer was prior to the act, prior to the rules also.
Mr. Ashok, please.
It's all right. You are entitled. See, like let you argue the party. Just the court will decide the matter.
No, absolutely. I'm just trying to make the point, Lordship. I'm specifically once you make a pleading. otherwise I'm making a speculative argument. Once you admit, so can you go back anything beyond 17? Could my humble request, Lordship, kindly please ignore all the other arguments forwarded because by their own admission they cannot be entertained. Oblige, Lordship.
Just say what you said. But you have completed their oral argument. Stop. Release this matter after a week to enable the parties to submit written notes, short written notes.
Yes.
Of the gist of the argument.
Lordship.
And just give one
No,
stop.
Lordship.
Head notes.
I got it.
Because if we hear it in piecemeal, then
It becomes
also
problem.
misses.
Yes,
So
Lordship is correct.
just
Absolutely.
to ensure that nothing is missed out.
Nothing, absolutely.
Nothing more. Thank you.
Obliged.